Yes, let's go straight to the courts. I had mentioned that earlier that yes, journalist Jaque Maribe was expected to be presented before court in relation to the ongoing murder probe that is making headlines today. Let's listen in to the lawyer speaking.
Since the 20th of September, that motor vehicle is at the police station. And we made two submissions in respect to that issue, Your Honor. The first one is, if it were to be the case that they actually wanted to conduct any investigation relating to that motor vehicle, we submit that the time they have had is adequate. However, and in any event, my client is prepared to say that they can have the custody of the motor vehicle for a reasonable time within which they can complete the investigations. And on that premises, Your Honor, we pray that you do find that that is not the reason why our client should be kept in incarceration. In other words, what is the purpose and what is the utility of denying her freedom when she has not interfered with the vehicle and when the vehicle is at the police station and she has never sought to access it or to take possession of it? The third issue raised is the issue of DNA, extracting the DNA, Your Honor. Your Honor, we can't see the relationship between the need to extract the DNA from her and the need to incarcerate her. However, I've taken instructions, Your Honor. I was just asked right here in court and I've taken instructions. If the prosecution are very interested in getting DNA extraction from her, she is prepared to give it as recent as right now, Your Honor. And in relation to that, Your Honor, my client would like to emphatically indicate that she is willing and happy to cooperate with the investigators to assist in these investigations. For all those reasons, Your Honor, in respect to the grounds that have been advanced with a view to seeking our incarceration, we do pray that you do find that the prosecution has not made out a case. I would like, Your Honor, to distinguish the fourth issue they have raised, being the issue of her phone being ground number C of the application, that they have seized her phone. Your Honor, we have an inventory from the investigating officer himself, dated 29 September 2018, by which they requested my client to hand over the phone, and she readily and happily gave them the phone. On that account, we maintain our argument, Your Honor, that that is not a reason to hold her. Your Honor, having covered those four grounds, I would like to make a few other comments, Your Honor. The first one is the tone used in the application. Your Honor, the tone used in the application is grossly misrepresentative. Your Honor, in paragraph A of the grounds, it is alleged that my client was arrested. Your Honor, on the 29th of September 2018, my client was requested to meet the investigators. She took herself to them. And not only did she take herself to them when they requested to meet her, this was the fourth time they have asked her to meet them. And she has always readily cooperated and attended to their summons. Telephone summons, not even a formal set of summons. And so, Your Honor, to make it seem to you like she's a difficult person, that she's a person whose cooperation necessitated the arrest is, Your Honor, misrepresentative and an unfair tone to adopt. Your Honor, in paragraph C, it is alleged that her phone was seized. Your Honor, my client was requested to surrender her phone, or rather, when she was being called to meet the investigators on the 29th of September, she was requested, an inquiry was made whether she has her phone and whether she can come with it, and she said, happily. She was also asked whether she had interfered with any messages, Your Honor, and she confirmed she had not interfered with anything. She handed over the phone. So to make it look like she was struggling and resisting the surrender and that it necessitated seizure as used in the application is grossly unfair, Your Honor, and is intended to influence your mind to get the impression that my client is less than cooperating. And we just want to emphasize, Your Honor, that she's cooperating. Your Honor, we will pray that the prosecution, in response to this application, do answer that issue, Your Honor. We have already indicated that she is cooperative, and ahead of appearing before you today, I had a word with the investigators, and they confirmed that indeed she is cooperating. And I would like you, Your Honor, to entertain this application with that background that she's been very ready and happy to cooperate. Your Honor, we want to take issue also with the idea that an accused or a party is just arrested and then an application is made to you to facilitate the investigations, Your Honor. Our position is that the Constitution presupposes that before somebody is arrested and is brought to court, the investigations have been completed and an informed view of culpability has been taken by prosecution. The scenario we are being invited to, Your Honor, is a situation where the prosecution are placing the horse before the cart by asking you to be party to the process of investigation, and in that process to violate the rights of a party. Your Honor, we pray and plead to what is called in law the conscience of a judge, that Your Honor, you recall your duty to be an arbitrator between ourselves and the prosecution and not to lend your hand to the prosecution, especially the hand that is being sought to violate the rights of my client. Two last things, Your Honor. If Your Honor were to be inclined to give them time, Your Honor, and we are saying it very normatively, Your Honor, if we pray that you allow them no more time than by Wednesday, Your Honor. Wednesday the 3rd. And Your Honor, we submit that it's reasonable enough time for whatever they want to do, which clearly is not on the face of the application. Your Honor, we will also pray that in that period, there be reasonable access to the accused, to the respondent, for her counsel. Your Honor, since incarceration on Saturday, it has sometimes been very difficult to access her. And when access has been given to counsel, Your Honor, it has been made available in a public place, which makes it very difficult for the confidential conversation that is necessary as between a client and an advocate to be conducted. Your Honor, we would also pray that over that period, there be no more recording of statements or attempts to extract content from the respondent in the absence of our counsel. And I say this, Your Honor, because my client has complained that she was under a lot of pressure to admit that she knows one Monica Kimani, when she had emphatically said she doesn't know her. And we are, as counsel, I'm worried that the pressure and the incarceration could in part be because she refused to acknowledge knowing her, being the truth of the situation, that she actually doesn't know her. And lastly, Your Honor, we would pray that if she has to be kept on hold, and as requested up to Wednesday, Your Honor, we would pray that she be kept at Gigiri Police Station. In a fair environment, Your Honor, and I say fair because, Your Honor, when she was under incarceration, people of doubtful circumstances were placed in the same incarceration, who kept inquiring from her what she knows about the investigators and what she knows about this case.
Those are facts. He's speaking from the back, my colleague. Those are things we should have been deponed to in an affidavit. You cannot speak from the back on such issues. That I would object to, Your Honor.
And may I know from my learned friend when she expected me to respond, when she practically gave me the application when I was on my feet, when she expected me to do that. And is she saying it is right for them either to plant people to get information from my client or to plant people who are related to third parties?
Objection, we cannot allow that to go on record. Those are not legal issues which can be brought on in this kind of scenario. You know, those are facts which can only be brought out in an affidavit. If they are facts, that is, I would object to that.
So what would be the prejudice? With babies obeying instructions from the suspect that himself and people say does not trust.
Your Honor, can that be reduced in form of an affidavit? We'll respond to it. We have the IO here. It's prejudicial, and it's actually an attack on the applicant, really.
Yes, Your Honor, we intend to attack the applicant. We have no doubt about that. But may I say this, Your Honor, because I don't want to prolong this issue. Your Honor, this respondent has been brought before you and you are the arbitrator, Your Honor. We pray that in considering whether to keep her, and we have said please release her. If it were to be the case that you choose to keep her for a couple of more days, Your Honor, we pray that the environment under which she is kept is not unfair to her, inclusive of her being blackmailed, being intimidated, being cajoled, Your Honor. That's all we are saying.
Yes, Madam. Are you aware of the negotiations between the investigators and the
Your Honor, I'm actually shocked. I didn't know any such kind of negotiations, because if there was any negotiation, it should have been done with the prosecutor, the person presenting this matter before Your Honor. There is no negotiation. Your Honor,
probably the investigating officer can be asked to say if it is not true. And he looks at me in the face and says it's not true.
Your Honor, a brief rejoinder. Council has submitted that the House is in full control of the being a crime scene. Your Honor, we don't deny that. What we are saying is that what has been collected from the House, the samples, the items, are going to be subjected for forensic analysis. This is what is taking, what is likely to take long, because after they collect the items and there's a report, the investigators again go back and carry out investigations. It's not as simple as that. That's what we are saying. Same goes with the vehicle, the motor vehicle itself. It's true the motor vehicle has been impounded. It's not the motor vehicle itself we're talking about. We're talking about what has been collected from the motor vehicle. That is what we need to be subjected to forensic examination. This is something which is likely to take long, and that is something we have confirmed this from the investigating officers. Even the DNA, even if the DNA, and I'm happy that Council Mr. Katwa has said that they are going to cooperate and have the DNA sample given today. Your Honor, it's not something which we are going to get a report today. We are likely to take a longer period to get the report out of the DNA. So what we're talking about is not what has been taken in custody of the investigating officers. It's what will be generated to form a report. Your Honor, on the issue of cooperating with the investigating officer, we are happy that she's cooperating. But again, we are saying, Your Honor, that the likelihood that if she is released before investigations are carried out, it will impede the whole investigation. What the investigators have started for a while, and they need to complete it properly. In fact, at the end of the day, we want to rightfully give the right charges, if at all, to the suspect. So let us allow us to carry out our investigations properly. Your Honor, also taking note that it's not just, you have to note that the general nature of the evidence that which the suspect has been arrested on, it's relating to serious offenses, which might be murder, accessory to murder, maybe in relation to issues of firearms. These are not light offenses, these are serious offenses. And this has been alluded to by the investigating officer. Your Honor, the issue of the rights of the suspect are contained in Article 24 of the Constitution. These rights are not absolute. It's worth noting that when the investigators feel that there is a likelihood that investigations are likely to be affected, then that is a compelling reason to have a suspect placed in custody. And a court order for that matter can allow for a suspect to be placed in custody. Your Honor, the 3 days counsel is talking about are not sufficient. You can see the kind of reports we are expecting to receive after the investigations are complete. It's therefore my submission, Your Honor, that the 3 days are not sufficient. The 14 days are what we need. Your Honor, in the affidavit, we had said that there are statements which have from friends and workmates. Of the applicant, which are likely to be, of the suspect, sorry, which are likely to be...
Respondent, not suspect. She's a respondent.
Well, we can call a respondent suspect anything, but respondent of the respondent, the fact that these are people who are close to her, the chances are that she is likely to interfere. Therefore, my humble prayer that this court gives us the opportunity to complete our investigations. In this case, which is not only for the family of the deceased, but it's also a public interest case. Our prayers are merited, and we have demonstrated as much. Please allow our application. That is my humble prayer.
I've made a short ruling, and the court has considered all the issues raised by the parties. Under Article 49 of the Constitution, the court has powers to detain a suspect pending a charge if there are compelling reasons advanced by the prosecution. In making such a determination, the court will take into account the nature of the investigations, the complexity of the case, and also consider if detaining the suspect is the most appropriate measure as set out under Article 24 of the Constitution. In any event, the court also has to balance the rights of the suspect and the victims of an alleged offense. So this court has gone through the contents of the affidavit as shown by Chief Inspector Otieno, and I'm convinced that compelling reasons do exist to warrant detention in custody. So in the interest of justice, I've granted the prosecution 10 days to detain the suspect at Gigiri Police Station. I've also directed that an advocate should be allowed access while she's in custody, and that she should not be forced to record any statement in the absence of an advocate. Further, on the issue of a safety which has been raised by Mr. Kangwe, of course that is not a curious application, and the court will take a judicial notice of the fact that recently, actually a suspect was found dead in a police cell. So I cannot say it is above expectation that the court should direct the safety of the respondent should be guaranteed while in custody. So those are the orders of the court. So 10 days will lapse when? And I've not said 10 working days, I've said 10 days. Wednesday the 10th. That may be a public holiday. We can put it 11. It may be a public holiday. No, let's give them 11. Okay, thank you very much.